Good afternoon, dear colleagues. Hello, dear participants of the forum. Today I will be talking about the experience of Roscosmos protecting the remote Earth sensing data and the intellectual property rights created on their basis. And we can use this example to show the interrelation between the legal aspects of data protection and about how this protection can address the challenges that emerge when you use new technologies such as AI. Today, in order to create analytical products and services that are based on the use of remote Earth sensing, you would use artificial intelligence products and a neural network whenever you process images from satellites. These technologies allow you to improve the quality of existing information products and create new ones that are in demand in various sectors. And you can use that in construction, in agriculture, energy use, environment, and in emergency management, among other things. In our experience, we learned that international conventions and national laws that exist do not allow us to effectively protect the remote Earth sensing data and the products that are created on the basis of that. This is because this type of data is very peculiar. It's not really structured, and there is not automated in terms of collection of data, and therefore we cannot harmonize this with the traditional types of intellectual property assets. But nevertheless, it is clear that these data would need to be protected, and that would be the only way to protect those significant investments that have been put into the creation of the infrastructure that are needed to collect this data. At the same time, you need to point out that this data is very important for the economy and for the economy of knowledge in particular. And we also need to identify who is the owner of the data and who is the owner of the intellectual property rights. When you structure deals where you use, let's say, remote sensing data and the products created on that, we are, of course, looking at what are the best types of agreements that best suit this purpose. A licensing agreement, which is a traditional type of agreement for intellectual property assets. You can see that on the right. Or it could be a service agreement, similar to the service agreement you would write with a mobile operator, where you use the infrastructure of that operator, but not use the intellectual property rights if proper. In our case, the licensing agreement has a preference because it provides the desired degree of flexibility in terms of further transfer of rights, and it can allow you to continue using the results afterwards. Nevertheless, there is some ambiguity, legal ambiguity, with regard to this type of intellectual property assets. There is a high risk of, that these data will be contested, and therefore we cannot use this type of agreement, and therefore would be interested in discussing the possibility of creating a new type of intellectual property asset so that it can be protected, let's say in the form of raw or unstructured data. And of course, the duration of protection is quite important, and you also need to define who is the rights owner. At the same time, you need to identify what is going to be the baseline for protecting these property rights when you use AI. Of course, this is a very general statement, but at the same time, I believe we all understand that the environment we operate in is changing with the advent of these technologies, and of course you need to somehow deal with how these technologies would need to be regulated. We need to regulate everything that can be regulated, and at the same time you need to identify what is the proper legal protection regime when you are protecting results that were created using AI. The problem here is that you don't have a very clear author of such results or outcomes, and the law in the area of intellectual property is based on the principle of an author. And the third premise we have is that we need to identify the process for using the preceding art when you are creating certain intellectual property systems and when you make them function. And you need to collect a lot of data for that, and some intellectual property assets can be protected as a result. And so we need to ensure that we don't infringe on third parties' rights. The fourth issue we need to discuss is what is the outlook for using AI technologies for governing administrative processes associated with the protection of intellectual property rights or IP rights. We understand that intellectual property offices can use AI in order to search for patent information whenever they make a decision whether to grant or not to grant a patent for an application. And it is clear that AI can help here quite significantly by slashing the labor cost, but at the same time, you still need to have some level of regulation here as well. And the very last aspect I wanted to dwell on, it is also quite important. It is important to create a basis for the national system of standardization and conformity. And thank you for your attention. If you have any questions, I'll be happy to take them. Thank you.